Hello, everybody. We're ready to start our program for lunch. I'm Nick Rosenkranz. I teach constitutional law at Georgetown, and I'll be your moderator today. So I'm delighted to be here, and I'm particularly pleased to participate in this event because it is a debate. Too often on law school faculties, there's virtual unanimity on the important issues of the day, with one side dramatically underrepresented or really not represented at all. This is a shame, I think, in law schools, and it's one of the core axioms of the Federalist Society that the best way to get to truth is through zealous advocacy on both sides. So we have the centerpiece of our National Lawyers Convention is a debate, and today, again, at the Faculty Convention, we again feature a terrific debate on one of the most important issues of the day. So our debate today is, in effect, the question presented by a pending Supreme Court case. And the case is King v. Burwell. And so what we have today, in a sense, is a preview of what the Supreme Court argument might look like. And the issue, briefly, is one of statutory interpretation, which is to say proper interpretation of the Obamacare statute. When Obamacare was enacted, many of its supporters hoped and assumed that all 50 states would set up state insurance exchanges. But Congress couldn't compel the states to do that, and so they had a backup plan. If a state didn't create an exchange, there would be the federal exchange, which is healthcare.gov. Now, as it turned out, only about a third of states actually set up exchanges, and so in the other 2/3, we have healthcare.gov. Now, the problem, though, is that much of the statute, and in particular, most of the insurance subsidies, which are a central feature of the statute, are available for insurance purchased on a, quote, exchange established by the state, close quote. So the issue is whether this language actually excludes healthcare.gov, which was, after all, created by the federal government. If it does, then the IRS has been providing subsidies without statutory authorization, and it's safe to say that whichever way this case comes out, it has enormous implications for the economic workings of this statute, and thus really for the politics of this statute, right? So we have two terrific debaters for this issue. Arguing for the motion is Jonathan Adler, to my right. He is the inaugural Johann Verhey Memorial Professor of Law and Director of the Center for Business Law and Regulation at Case Western University Law School. He teaches environmental, administrative, and constitutional law. He's one of the first to notice this quirk of the language of the statute, and he and Michael Cannon are really the architects of this case, and he'll also be filing an amicus brief in the case. Arguing against the motion to my left, Nick Bagley, Assistant Professor of Law at University of Michigan. He teaches administrative law, regulatory theory, and health law. Nick's written and spoken widely on our issue today and is really one of the most thoughtful commentators on his side of this issue, and he also will be filing an amicus brief in the case. So we truly have two of the nation's experts on this issue to join in the debate. Now, our format is we'll hear 12 minutes for, 12 against, a 7-minute rebuttal, a 7-minute rebuttal on the other side, then perhaps a somewhat less structured give and take, perhaps spurred on by the moderator if necessary. And then we'll take questions from the audience as time permits. So once again, our resolution, you have it on the screen, resolved that the Affordable Care Act does not authorize subsidies for individuals purchasing health insurance through federal exchanges. Arguing for the motion, John Adler.
Well, thank you, Nick. You guys can hear me all right? It's a pleasure to be here to talk about this issue. Pleasure to be debating Nick Bagley again. We've debated this a whole bunch of times at this point, and it's a pleasure to cross swords with him again on this. There's a lot of stuff out there about this case, which is not particularly helpful or probative. Hopefully, this exchange will be both helpful and probative in thinking about this case and what the court is going to do, or what it might do, or what it should do. Now, just to start off with the statute, it's obviously a long, complicated statute. I don't suspect many of you have read the whole thing. I'm sorry if you've had to do that. It's not a pleasant experience, but a few years ago, I was prompted to do so when asked to present a paper on some of the federalism aspects of healthcare reform, and that led to recognition about some of the statutory language that led to some work that I did with Michael Cannon that apparently led to some lawsuits. And so what's is this about? Well, the statute does a bunch of things. One of the things it purports to do, or aims to do, is to facilitate the purchase of health insurance through the creation of exchanges. The idea is these are supposed to be Expedia or Travelocity or Orbitz for healthcare, and allow individuals to comparison shop for health insurance. Also allows the government to ensure there's a certain degree of uniformity, certain regulatory standards are met. The hope was also that this would be a way to provide tax credits and cost-sharing subsidies for the purchase of health insurance. The way the statute does this is in section 1311 of the statute. It says that states shall establish exchanges. It gives a direct command to states to establish exchanges. Now, as we all know, the federal government can't just do that. It can't just tell states what to do. For good or ill, states are not vassals of the federal government. They are not required to execute or administer federal programs. They can be encouraged or incentivized to do so, but they cannot be commanded to do so. The statute, in addition to telling the states to establish exchanges in a separate provision, it tells the federal government that if the states fail to establish exchanges, and also, or if they fail to take some other administrative steps they're supposed to take, that the Secretary of Health and Human Services shall establish and operate that exchange. So we have on the one hand a provision that says states shall establish. On the other hand, we have a provision that says if states don't, the feds shall establish. So these provisions distinguish who is in fact creating the entity at issue, who is creating the exchange. And then in a separate provision of the statute, section 1401, which creates section 36B of the Internal Revenue Code, tax credits for individuals, and then cost-sharing subsidies, which are essentially payments to insurers, are authorized for the purchase of qualifying health insurance in exchanges established by the state under 1311. And so the issue in the case is whether or not this language that I would argue fairly clearly authorizes tax credits for the purchase of insurance in exchanges established by the state can be read as well as authority to provide for tax credits and subsidies for the purchase of insurance, not in exchanges established by the state, but exchanges established by the federal government. And just to go into a little more depth on section 1401, in two separate places in section 1401, the statute expressly conditions the tax credits on the exchange being established by the state. It does so both where the premium assistant amount is calculated. It does as well in identifying what is the coverage month. The way this works is basically to get a tax credit, you have to have been covered for a month. That's the time period that's used. And a coverage month is determined by, are you enrolled in a plan through an exchange established by the state for the relevant month. This may seem an odd way to do this sort of thing. It's actually not odd when it comes to tax law. There are other provisions of the Internal Revenue Code that use similar structure. As an environmental guy, this seems kind of odd, but I'm sure many tax people would look at the Clean Air Act and say a lot of what we do in environmental law is kind of odd. This sort of structure is not all that unusual for the subject matter. What's also interesting about this language is that it did not all come from the same place at the same time. That is, the established by the state phrases in these provisions were added at separate times in the drafting process. One came out of the Senate Finance Committee. The other was added essentially in Senate Majority Leader Harry Reid's office as the bill was being edited and revised before being sent to the floor. So this was not just something that was a holdover from a single prior bill. This was language that was added multiple times in multiple places in the statute. Now the IRS, despite this language, despite the fact that career staff attorneys originally were going to issue regulations that merely tracked the precise language of the statute, ended up promulgating a rule that says a taxpayer is eligible for the credit if the taxpayer or a member of the taxpayer's family is enrolled in one or more qualified health plan through an exchange established under Section 1311 or 1321 of the Affordable Care Act. No mention of who's establishing the exchange and referencing both Section 11 and Section 1321. This was what the IRS proposed in August of 2011 and then finalized in early 2012. You may ask, well, why would the IRS think they could do that? It's a good question. Again, the statute says tax credits are through an exchange established by the state under Section 1311. IRS says through an exchange established under Section 1311 or 1321. Just for good measure, it may be worth noting that state is actually defined in the statute to mean one of the 50 states or the District of Columbia. So you can't say, oh, state just means government. No, it actually is defined to mean one of the 50 states. So why would the IRS think it could do this? Well, for those of you that teach administrative law, this paragraph, I won't read the whole thing, is the entire explanation the IRS gave when it finalized its rule. There is no supporting to any no reference to any specific statutory language, a oblique reference to relevant legislative history, but again, citation to nothing specific. All they really said was, well, there's nothing in the legislative history that demonstrates we can't do this, and this is broadly consistent with the language, purpose, and structure of the relevant provisions and the Affordable Care Act as a whole. Of course, that could be said of all sorts of policies the IRS might want to adopt. That could justify perhaps authorizing tax credits to all health insurance, whether it's purchased in an exchange or not, or perhaps to disregard the income requirements for tax credits, because the statute both imposes an income ceiling and, believe it or not, an income floor on eligibility for tax credits. That is, you can earn too little to get tax credits. The same broad purpose, expanding coverage, would certainly justify ignoring that too. But of course, the IRS hasn't suggested that, at least not yet. The IRS cited no particular basis for this rationale or for its ability to do this. Eventually, after being questioned by members of Congress, and after being questioned by the media, and after some academics began to weigh in, the IRS seized on a remedy. One thing I should note that they never pointed to, and they have still yet to point, no dog was harmed in making the slide. Some things that the IRS had never pointed to, and at the time, and is still not pointed to today, in fact, no one has pointed to, is, for those of you that believe legislative history is important, there is not a single contemporaneous statement made by anyone making the following claim: tax credits are available in federal exchanges under the PPACA. That claim was never made at the time. People said tax credits would be available in all 50 states, but they also said, repeatedly and regularly, but all states, of course, will cooperate. And it would certainly follow. If all states create exchanges, then of course there would be tax credits in all 50 states. But there is not a single contemporaneous statement by anyone that anyone's been able to find, and to this day, it surprises me that not even an email has materialized, just saying, oh yeah, and there'll be tax credits in federal exchanges under this bill. So the IRS didn't point to anything because there was nothing for the IRS to point to. Now, eventually, they made the argument, months after finalizing the rule, that language in Section 1321 would, in fact, authorize what they did. Because Section 1321 says that if the state fails to create the required exchange, then the secretary shall, directly or through agreement with a not-for-profit entity, establish and operate such exchange within the state. And the argument is that such exchange is the required exchange. The required exchange is the exchange mandated by 1311. Therefore, a 1321 exchange is a 1311 exchange. Again, the IRS hadn't thought about this when they promulgated the rule, but months later they came up with this rationale. It is one of the rationales the government and some of its amici make today. It's an interesting argument, but it has some serious problems. One is, and this slide is built on something that my co-author Michael Cannon did, is that it requires us ignoring certain language in the statute. So the theory is, right, 1321, by saying required exchange and such exchange, creates a 1311 exchange even though it's a 1321 exchange. But that requires us ignoring the fact that we have this language established by the state, which appears not only repeatedly in section 1401, it appears elsewhere in section 1311, it appears elsewhere within the statute. And it requires us simply ignoring that. And it creates problems if we ignore that, because there are many places in the statute where if established by the state doesn't mean established by the state, we have problems. If a 1321 exchange is a 1311 exchange, not only are we ignoring language that serves no other purpose in the statute but to differentiate exchanges based on who established them, we create situations like in section 13F, for example, where a state is in the position of authorizing what a federal entity is allowed to do or not allowed to do. Because 1311 says the state gets to decide whether the exchange established by the state can enter into certain agreements to carry out, with entities to carry out certain subsidiary obligations or functions of exchanges. That makes perfect sense if we're talking about a state giving permission to a state entity. It creates problems if it's a state deciding whether or not the feds are allowed to do something or not. Section 2201 does the same thing. Section 2201 is expressly conditioned, or expressly creates conditions on the receipt of Medicaid money. And it says that among the things that states have to do to continue to receive Medicaid money is to make sure that exchanges established by the state utilize electronic interfaces that are secure for the purposes of determining benefit eligibility. Again, a requirement for how a state operates a state exchange, that makes perfect sense. For a condition for getting Medicaid money that requires a state to force a federal exchange to do stuff, again, we have real problems. The state can't tell the feds what to do. The state can't be told, you lose your Medicaid money if you can't ensure to us that the federal entity is doing what we want it to do. Right? It creates problems throughout the statute. Nick, I'm sure, will argue that my interpretation creates problems. In rebuttal, I'll have to explain why he's wrong. But there is not a single word in the statute that has to be ignored or omitted for established by the state to take on its plain meaning. I'm told to stop, so I'll just say, why would Congress do this? Congress has done it before. Experts proposed this precise mechanism here. It was done in antecedent bills. It avoided the federal takeover charge. What we got enacted was a negotiating draft, and Congress had no choice because of the election of Scott Brown. It was this bill that many people didn't like, or no bill. Nancy Pelosi said we have to pass the bill so we can find out what was in it. We thought she meant we'd then have the time to read it. What she apparently actually meant is we'd have to see how the administration was implementing the law to understand what it was that we're actually living under. And I will stop there. Thank you. Thanks.
Nick Bagley, arguing against the motion.
Yeah, thanks to the Federalist Society for inviting me today, and to Jonathan for agreeing to go head-to-head with me again. I asked Jonathan when he showed up this morning whether he was the dog or the pony this time. I feel like we're going to keep doing this until at least the Supreme Court decides this case at the end of June. I'd like to clear something up right away, and building on something that Jonathan said. When the federal government sets up an exchange on a state's behalf, it doesn't create some sort of federal exchange. Rather, the federal government creates a state exchange, and the text of the ACA is crisp on this point. Recall that Section 1311 instructs states to set up their own exchanges. Section 1321 says that when a state fails to set up the required exchange, which is to say a state exchange under Section 1311, the Secretary of HHS must establish and operate such exchange. In other words, the backup exchange isn't established under Section 1321. It's established under Section 1311, just as the provision authorizing tax credits requires. I'm not 100% sure, but I don't really take Jonathan to contest that basic point. And so understood, the Secretary just stands in the shoes of state officials in setting up their state's exchanges. Any exchange that she establishes is the legal and functional equivalent of a state exchange. Not so fast, Jonathan says. And the statute doesn't just link tax credits to exchanges established under 1311. It links tax credits to exchanges established by the state under 1311. And according to Jonathan, Congress used those three words, by the state, to signal that tax credits would be unavailable on federally established exchanges. And the argument, if accepted, would have extraordinarily serious consequences. About 9.5 million people in the 34 states that declined to establish their own exchanges are eligible for tax credits that in 2014 were worth about $2,890 per person on average. So the case, no matter how you cut it, is an extraordinarily big deal. The trouble with Jonathan's argument is not that it's crazy, right? You can understand where he gets this claim. The words by the state do appear in the statute. The trouble with Jonathan's argument is that the Supreme Court has been abundantly clear time and again that you cannot read statutory phrases in isolation. Sometimes reference to the broader context of a statute confirms that a snippet doesn't mean what it might at first appear to mean. This is not, I should emphasize, a controversial point. It's one that both textualists and purposivists embrace. All interpreters seek to ascertain the meaning of the statutory language that Congress selected, and they examine the whole statute in trying to determine that meaning. So if you read the Affordable Care Act as a whole, it's apparent that Congress never meant those 3 words to bear the immense weight that Jonathan would assign to them. It's not only that Congress instructed the Secretary to set up a state exchange, reinforcing the suggestion that she just steps into the shoes of state officials. In several places in the Act, Congress clearly used similar exchange established by the state language to refer generally to exchanges, including federally established exchanges. And if that's true elsewhere in the statute, why not in the provision governing the calculation of tax credits? First and foremost, the ACA allows only qualified individuals to buy health plans on the exchanges. But a qualified individual is defined as someone who resides in the state that established the exchange. Does that mean that no one can purchase a plan in those states that have declined to set up exchanges? The federally created exchanges would have no customers and no purpose. That cannot be what Congress meant. But that's what the reading that Jonathan's reading would accomplish. The much more natural inference is that an exchange established by the Secretary should be treated as the statutory equivalent of a state-established exchange. Second, take the statutory provision that explicitly authorizes every exchange. Oh, I'm sorry, I'll go next. Every exchange, including those established under 1321, the statute is quite clear here, to provide information to Treasury about the aggregate amount of advanced tax credits that each individual receives when purchasing a plan on the exchange. The point of this provision, as the title of the subsection in which it appears states, is to allow for the reconciliation of credits and advanced tax credits. Why insist that federally established exchanges share information about tax credits when no one buying a health plan on those exchanges can ever get them? Third, the ACA says that states have to maintain their Medicaid eligibility standards until, quote, an exchange established by the state is up and running. This maintenance of effort provision was meant to provide stopgap protection for Medicaid beneficiaries until the exchanges went live. On Jonathan's telling, however, the provision would just forbid a state that declined to establish an exchange from ever relaxing its Medicaid standards. And there is zero evidence that Congress meant the ACA to freeze state Medicaid programs into perpetuity. Jonathan, however, brushes by all of these statutory textual signals, insisting that the phrase established by the state is used all over the statute. But it doesn't matter how many times Congress used the phrase. It matters what Congress meant by the phrase. And its repetition is perfectly consistent with the view that Congress, anticipating that all or nearly all the states would establish exchanges, used the phrase as a reference, a shorthand reference to exchanges in general. So falling back on the canon against surplusage, Jonathan says, no. Those words by the state must serve some distinct purpose. So what's that purpose? Well, Jonathan scratches his head a while and says, okay, in his view, Congress withheld tax credits from states that declined to create their own exchanges in order to goad them into establishing those exchanges. Congress was making a threat. Set up your own exchanges, or you're going to lose out on tax credits. That is a completely untenable understanding of the statute, however. To begin with, and most fundamentally, a threat isn't a threat unless it's communicated. When Vito Corleone made the proverbial offer that couldn't be refused, he didn't just say, sign the contract. Right? He had Luca Brasi hold a gun to the head of the guy and say, either your brains or your signature will be on the contract. Without the gun, there is no threat. Here, however, this threat was so well hidden that the states didn't even notice it, and that no one even mentioned it. A careful report from the Georgetown University Health Policy Institute documenting what states knew and when they knew it has found no contemporaneous evidence that the availability of tax credits played a role in state decisions over whether to establish exchanges. No gun, no threat. And no wonder the states didn't notice. The phrase established by the state under 1311 is awkwardly crammed in subsection B2A in a section of subpart C of part 4 of subchapter A of chapter 1 of the Internal Revenue Code. It's outlandish to think that Congress inserted the innocuous words "by the state" into the complex calculation of the tax credit in order to issue a threat of this magnitude to the states. After all, Congress knows how to threaten states with financial consequences when it wants to. Any number of bills, as Jonathan has pointed out rightly, but not the ACA, contain clear language conditioning federal money on certain forms of state compliance. The absence of any such clear language in the ACA is powerful evidence that Congress never meant the availability of tax credits to depend on whether a state established an exchange. And after all, think about it. There would have been no need to bully the states into doing what everyone at the time assumed they would gladly do in order to maintain control over their insurance markets. The notion that Congress meant to threaten the states in this fashion is doubly implausible because these backup exchanges just wouldn't work. In the absence of tax credits on these federally established exchanges, many healthy people would forego coverage. They'd just drop it. They couldn't afford it. Those with serious health problems, those who need medical care, would remain in the market. And the risk pools for exchange plans would deteriorate. They become skewed towards sicker and sicker enrollees, which would in turn increase the cost of exchange plans. As costs go up, relatively healthy people would decline insurance in greater numbers, leading to sicker risk pools and even higher prices, which would drive away still more healthy people. In a word, the exchanges would stop working. As a recent released study from the Rand Corporation says, if the ACA's subsidies are eliminated entirely, our model predicts a near-death spiral. That is, sharp premium increases and drastic enrollment declines in the individual market. Why would you construe the ACA to create dysfunctional exchanges when a plausible alternative reading would avoid that result? And the context in which the ACA was adopted just reinforces the point that there was never any such threat made. The debate over the ACA didn't exactly pass unnoticed. We all remember it. It was a big deal. Its provisions were subject to intense scrutiny. No one during the debate, no one, ever said that the statute that Congress enacted was meant to strip individuals on federally established exchanges of subsidies. If you're looking for a dog that didn't bark, that's the dog. I'm the pony. Finally, it'd be very strange to construe the ACA in a manner that would allow the states to so easily defeat its core purpose of achieving near universal insurance. If an alternative reading is available, and it is, why would you construe a statute so that it would be at war with itself? That's especially so when the alternative does a much better job making sense of the act as a whole. But here's the bottom line, all right? So even if you don't agree with me about the best reading of the statute, even if you think I'm wrong, surely you'll admit that reasonable minds can differ about whether the statute requires the withholding of tax credits on states with federally established exchanges, which is to say the statute is ambiguous on that precise point. And under Chevron, it's the IRS that has been delegated the authority to resolve that ambiguity. The IRS rule is thus an entirely reasonable construction of the ACA, one that advances the ACA's effort to provide near universal coverage, and one that is owed deference by the courts. All of which is to say, the outcome of this case should not depend on whether you're a textualist, a purposivist, a Republican, a Democrat. For the strictest of textualists, statutory context can help make sense of statutory meaning. And here, that context points in one direction, that tax credits are and were meant to be available in states with federally established exchanges. And because the IRS rule just confirms that common sense interpretation, it should be upheld. Thank you.
Jonathan, 7-minute rebuttal.
Nick and I definitely agree that looking at the whole text in context is important. Where we disagree is whether or not we should read language to mean something other than what it says. The word establish is used throughout the statute, and it clearly means establish. It's different than operate, it's different than manage, it's the act of creation. The Act refers to all sorts of entities and things that are established by the Secretary, by states, by other federal agencies, as it does in the relevant provisions here. The statute authorizes tax credits and cost-sharing subsidies. It says, among other things, it must be on an exchange. How do we know? Because in Internal Revenue Code Section 36B, where the tax credits are authorized, it tells us they have to be on an exchange. It tells us it has to be an exchange under Section 1311. Why? Well, because again, in Section 36B, it tells us that's where the tax credits are authorized. That's also where it says established by the state, not simply where it calculates the premium assistance amount, but also where it defines coverage amount. And where it all, and also in additional, I believe it's 7 cross-references throughout Section 36B, which all make very clear it's always talking about the same exchange. That's also where we see the requirement that the individuals aren't beneficiaries of other forms of public assistance, where we see both the minimum and maximum income requirements. They're all where you'd expect them to be, in the portions of the Internal Revenue Code that authorize the tax credits. And in fact, they are in the same place that prior statutes that have authorized favorable tax treatment for certain types of healthcare purchases were placed. It's either Internal Revenue Code Section 35 or 35B that created a healthcare tax credit that also originated in the Senate Finance Committee, where Senator Baucus was also at the time the ranking Democrat, I believe, that also conditioned these tax benefits on states enacting laws that complied with federal requirements for the individual taxpayer to get the tax benefit. There is nothing new here in the way this operates. That language was just as complicated, yet no one ever said, oh, it's not a condition, it's not a requirement. It was just commonplace. No one ever said this is a threat because, as Nick himself has written, everyone expected all 50 states would happily go along. There were going to be tax credits. Where were they going to be? In the exchanges. Which exchanges? Under the Senate bill, the state exchanges. Now, the House didn't want state exchanges. They didn't want state exchanges precisely because they didn't want to rely upon state governments. The White House apparently didn't want state exchanges either. At least that's what the contemporaneous reports said just before and just after Scott Brown was elected, depriving the supporters of the law with the 60th vote they needed. But in the Senate, the discussion always was, if we're going to have state exchanges, what requirements are we going to impose on states, and how do we convince them to do it? And we saw outside commentators recommending, among other things, condition these tax credits on state cooperation. We saw other Senate bills, the HELP bill, for example, condition tax credits, in some cases temporarily, in some cases permanently, on state cooperation and implementation of federally desired measures. If a state failed to adopt the employer mandate under the HELP bill, its citizens could not get tax credits for the purchase of insurance on exchanges. So this wasn't something that was invented after the fact. This was something that was being put into the various proposals. It was something that was being discussed. Was it being discussed on the front pages of the Washington Post? No, because people were talking about abortion and talking about the public option. As the New Republic, I believe it was Jonathan Cohn acknowledged, that at the time no one was paying attention to these provisions because there were other things about the bill that were sucking all the air out of the room. Now, in terms of the language and of the statute provisions that Nick mentioned, let me just note them very quickly. The qualified individual provision in Section 1312 is talking about Section 1311 exchanges. How do we know? Well, because the statute says the default definition of exchanges are those under 1311. It then also says, though, this is just a default definition, that there are non-1311 exchanges. The definition is expressly made one that applies unless the relevant statutory provisions otherwise specify. Section 1312 is one of numerous provisions that are imposing requirements on states. And Section 1321 authorizes the federal government to create parallel requirements for its exchanges. So the qualified individual requirement is no problem at all. And even if that provision is ambiguous, that doesn't make Internal Revenue Code 36B ambiguous. How do I know this? Well, I could look, for example, at the Supreme Court's decision last term in a case called Utility Air Regulatory Group versus EPA involving the Clean Air Act, where the court explained just because you have an ambiguity in one part of a long, complex statute, because there's a word or phrase that may have some interpretive room to adopt alternate meanings, doesn't mean the entire statute is ambiguous, and certainly doesn't authorize an agency to disregard clear statutory terms and phrases. So while the phrase any pollutant could be somewhat ambiguous based on its context, as the court concluded, the phrase 100 tons per year is not ambiguous. And similarly, the word exchange without modifier might be ambiguous. I think there's at least a plausible argument that the phrase under 1311 is ambiguous, whether or not it means properly under 1311, or it means 1311 or by operation of law under 1321. But established by the state, which is repeated in the relevant provisions, is not ambiguous. The reporting requirement, what Nick didn't tell you about that requirement is it expressly applies to both 1311 and 1321, and it identifies both provisions. If they're the same thing, that would have been unnecessary. What else is interesting about that requirement? It was part of the reconciliation bill. It was adopted after the fact. So when Congress itself looked back at the ACA and they said, we want to impose reporting requirements on both state and federal exchanges, did it just reference one of them? Did it just reference 1311? No, it referenced both 1311 and 1321. And under either of our interpretations, thousands, if not millions, of healthcare transactions in exchanges in which no credits are authorized will have to be reported under those provisions. Because they apply to all insurance purchases on exchanges, whether or not there are tax credits. And moreover, as the government has conceded, those reporting requirements, because of other things that are required, are necessary to implementation and operation of the Act. They conceded that before the D.C. Circuit, or just before the D.C. Circuit's argument in the Federal Register. The MOE requirement, the condition on a state is there under either of our interpretations. The only question is whether or not the condition imposed upon a state for whether or not when it gets to change its Medicaid eligibility requirements, whether or not it's solely dependent upon state action, or whether it's dependent upon either state action or federal diligence in creating an exchange. So the condition that Nick thinks is absurd is there either way. The only question is whether or not a state that does not want to cooperate has to sit there and hope that the federal government is going to create an operable exchange on time so it can change its Medicaid provision. As we know from the oral argument of NFIB, that sort of situation where the penalty or incentive on a state is not a function of state conduct, not the function of a clear rule, but a function of what the federal government does or does not do within the administrative process, is more problematic than a clear rule with a severe penalty. And yet that's the interpretation Nick wanted to mention. And of course, he hasn't mentioned the other provisions in the statute, the ones that say to states, you can lose your Medicaid money if you don't force the federal government to comply with the law. We're going to talk about doing violence to the text of the statute. That sort of interpretation, I think, is much more problematic than worrying about whether or not the qualified individual language applies only to 1311 exchanges or applies to all exchanges. Last thing on the Georgetown report, the state of Oklahoma, which was the first to file this claim, filed its suit before the deadline for electing to create its own exchange. And the state of Oklahoma said one of the reasons we're filing this suit is because we don't want the tax credits because they trigger employer mandate penalties. Any report that did not account for the fact that a state not only had pointed this out, but filed suit before the relevant deadline, I would not credit with being a comprehensive assessment of what state policymakers did or did not do, or did or did not know before the deadline. And like I said, Oklahoma filed its suit well before then. And I'll stop there.
Nick Bagley, 7 minutes.
Yeah, so I appreciate that Jonathan wants to take a look at the whole statute. He agrees that you can only make sense of even isolated snippets of text if you look at the whole statute and try to make sense of it as a whole. And he accuses me of doing violence to the statute. And I take the point. I understand where he's coming from. But just think how much more violence Jonathan does to the statute. There would be no qualified persons in any of the 34 states that refuse to establish exchanges. He says, no, that provision applies only to 1311 exchanges. But as I explained, federally established exchanges are 1311 exchanges. Even on his own rationale, that argument doesn't hold water. Federal exchanges would have to report tax credits for the purpose of reconciling advanced tax credits and the end-of-the-year tax credits for no good reason. Eligibility standards for state Medicaid programs would be frozen into perpetuity. On the off chance that these healthcare.gov exchanges were allowed to sell health plans in the first place, these fallback exchanges that Congress so carefully planned for would be basket case markets that didn't work. And hostile states, moreover, could thwart the ACA's effort to extend near universal insurance coverage. In other words, Jonathan's interpretation just doesn't sort of tweak the statute here and there. It would wreak havoc with the statute as a whole, much more than with the government's proposed construction. And if the goal of the interpreter is to make the best sense of the statute as a whole, I think the government has the better of the arguments. But again, I get back to the core point. if you don't agree with me, surely reasonable minds can differ. There is violence to the statute going to be done. According to Jonathan, on my version of the statute, certainly he would acknowledge some violence on his. That violence creates, well, I'll acknowledge for him. Qualified person? Come on, you got to give me that. But actually, this is kind of the point that I want to make, right? Like, I'm willing to give a little, to say, look, this isn't the sort of a model of draftsmanship or clarity. I'm willing to give that, right? It was passed under extraordinarily difficult circumstances. Most big pieces of congressional legislation are, right? We still need to take them seriously as statutes. You can't put a fork in it just because you don't like how it was enacted. And where I'm willing to give an inch and say, yeah, I understand that there's a little bit of room here to argue on the margins, Jonathan can't and won't. Because the moment he acknowledges any doubt, Jonathan loses. And that's what this case is about. The interpretation the IRS has offered of a statute that, at a minimum, is ambiguous on whether or not tax credits are available on federally established exchanges. I want to close by just shifting ground a little bit, by just talking briefly about the consequences of what an adverse ruling would be if this rule were invalidated. I want to do this not necessarily because it has any strict legal relevance, just to be clear, but just so we can understand what the stakes are here and what might happen next. The 34 states that have declined to establish their own exchanges probably wouldn't be able to stave off the immediate destabilization of their insurance markets. The court released its opinion in late June, almost certainly. Its decision would take effect very shortly thereafter, wiping out the advanced tax credits that would help to finance coverage for, at that point, about 7 million people who purchased insurance on healthcare.gov. In all likelihood, those people would be immediately asked to pay full freight for their insurance, which most of them couldn't afford. Enrollees who are unwilling or unable to pay that full amount will drop coverage. Probably as soon as 30 days after they fail to make a payment, they will no longer be covered. So by late summer, we will see enough of these people shed coverage that insurers would suffer extraordinary losses. Reinsurance companies would have to pick up the balance as with the risk corridors. Most insurers in these circumstances will refuse to participate in the exchanges in 2016. Those that remain will have to double or triple their premiums to deal with the adverse selection. Now, the 7 million people who are going to lose their tax credits, they are sure to put a ton of pressure on their state officials to establish exchanges. Come on, establish an exchange and we get our tax credits back. It is much too optimistic to think that the states will, as a group, just snap their fingers and establish their own exchanges. For one thing, setting up an exchange is not child's play. By statute, exchanges are going to have to be nonprofits or state agencies. They've got to be capable of discharging a number of statutory functions. Setting up an exchange requires a considerable investment of time and resources. For another thing, you got to have legal authority to do it. And a lot of these states don't have legal authority. 7 have prohibited their governors from cooperating in any way with the Affordable Care Act. Even then, only 8 of the 34 states that don't have their own exchanges, only 8 of them have legislative sessions that even extend beyond the court's decision date, which means they'd have to call a special legislative session in order to get any kind of state legislative action. And that assumes at the end of the day that these states will want to establish their own exchanges. And that's by no means a given, political pressure notwithstanding, especially after the 2014 elections and the antipathy on the right and in many of these state houses to the Affordable Care Act. Nor is a dysfunctional Congress, riven by partisan bickering, likely to pick up the pieces here. Sure, a one-sentence statute could fix this problem. I don't hold out any great hopes for that statute getting drafted or signed into law. And to what end? Right? Congress here is not likely to repeal the wildly popular ACA rules that prohibit insurance companies from discriminating against those with pre-existing conditions. So what are we going to get? We're going to get a bunch of states with basket case individual insurance markets, stubbornly high rates of uninsurance, and millions of unnecessary bankruptcies. Even if you don't much like the ACA, it's really hard to see how that's a desirable outcome. Thanks.
Terrific. So that ends the most structured part of our program. I'd like to invite our debaters. Do you want to make any final points or ask each other any questions that you feel are still on the table?
I mean, I would just say I agree with Nick that the victory by the plaintiffs would be significant as a practical matter, and I certainly think, therefore, members of Congress have an obligation to plan for that possibility. The administration has an obligation to plan for that responsibility. based on comments made at a recent hearing, the administration has essentially said it's making no contingency plans. I hope that wasn't true, because that would be grossly irresponsible, but it does seem to be that. Just in terms of, would Congress allow
I will agree with Jonathan on that.
Would Congress allow states to sabotage the goals of expanding coverage? Medicaid. I mean, they did. The only question with Medicaid was how big the stick was they were willing to hit the states with. But as a matter of law, even before the NFIB decision, states had to at least be given the patina of a choice about whether or not to accept that expansion. And states saying no to Medicaid expansion would do a lot more harm to vulnerable populations than this, because it would have required, prior to NFIB, the loss of benefits that existed under the old Medicaid, which are to some of the most vulnerable populations in our society. After NFIB, it's to those with lower income, including those who, under the statute, earn too little to get tax credits. The statute says you can earn too little to get tax credits. That may seem bizarre, but it says, oh no, if you earn below a certain amount, no tax credits. Oh, and if a state doesn't expand Medicaid, you basically then get no benefit from the law. So it's undisputed that the law in various places does things that give state a very powerful veto, and that does things that work against its goal. And then lastly, just on 1311 versus 1321. 1321 exchanges were carefully planned for. The law appropriates and authorized not a single penny for their implementation, but it did do some things when it came to their implementation which create real problems for saying 1311 and 1321 exchanges are the equivalent. For example, 1311 exchanges are barred from using federal funds for their operation. If that applies to a federal exchange, how do they operate? I don't believe we can say that a user fee imposed by a federal agency in a federal entity is something other than federal money. Similarly, when HHS decided to fund the federal exchanges, it did not use the pot of money that was created for state exchanges. There was a special pot of money, basically an unlimited pot of money, authorized to subsidize state exchanges. HHS did not say, oh, they're the same, we can use that money. No, it went through great lengths to find other places that it could find money to use, because it knew that money didn't work, and it didn't have any other money expressly appropriated for that purpose in the statute that's supposedly carefully planned for these exchanges. Again, why was that? They thought all states would cooperate. They also probably thought that the Senate bill wasn't the bill that would become law. Neither of those things justify ignoring the text of the statute that we have, and that's a real problem with saying this 1311 equals 1321 equals established by the state, because it requires us ignoring all sorts of things in the statute, ignoring what the federal government is actually doing with its implementation. And I don't think it requires ignoring anything in the text. The federal government, while making the qualified individual argument, has yet to say, if we lose, no one is eligible to buy insurance in any exchange. Right? So they don't believe, at least they have yet to claim, that the plaintiff's interpretation would require all exchanges to fail, which is what Nick says my interpretation requires. Well, the feds haven't made that argument yet. Now, maybe they will. Maybe they'll go that far. Maybe they'll commit to adopting that interpretation. I don't think they will, because Section 1312, that includes the qualified individual language, is either ambiguous or it's limited to Section 1311. But that doesn't mean Section 36B is ambiguous. It doesn't mean established by the state means anything other than established by the state. Read the Medicaid provisions of the PPACA and ask yourself, would a member of Congress reading those provisions have understood what it was really doing? And I would suggest if they weren't a member of the Finance Committee, they'd have no clue. And read the provisions. Because they never expressly say, oh, by the way, you lose all of this money. They say funds under provision X, title, blah, blah, blah. Read established by the state. I posit that even the dimmest member of Congress can read the phrase established by the state, and they would know what that means. It's clear, plain language, and that's what courts should be bound by.
My only point, one of the ways that this case has been framed is if, the question is the language of the tax credit provision absurd? And I think that's a mistaken way to understand what's going on. And Jonathan is putting those words into my mouth when he says, oh, he's saying qualified individual thing is absurd. Well, I can construe it in a way that makes it not absurd, and in any way you can't get away from the plain language of the statute. That's not what I'm arguing at all. What I'm trying to say is when you have a statute, a big statute, a complicated statute, part of the goal is to try to make it work as well as humanly possible given the text of that statute read as a whole. And so what you're trying to do is read the statute for clues about what Congress meant. And lots of those clues are going to be located in scattered portions. The more that Jonathan has to work to say, hey, this provision doesn't look like it works on its face, but I can read qualified individual to only apply to 1311 exchanges and not 1321 exchanges. If I squint and look at it in any way, it's not really absurd. The more he has to do that, the more he is simply ignoring a bunch of relevant context clues. He comes back to the snippets of text in section 36B and ignores the broader context of the statute. If you read the statute as a whole, it is very difficult to make sense of a number of provisions, not only the ones that we focused on here. And if you take that seriously, at a minimum, you get to ambiguity on the central question here. And once you get to ambiguity, the IRS wins this case, and the government should win this case.
Great. So let me ask a couple of questions. First of all, you have both made a sort of dog that didn't bark argument. You say no one suggested that the statute works the way Nick says it works, and Nick says no one suggested the statute works the way you say it works. What is the resolution of that issue? Will you concede that you have reached stalemate as to that?
Sure. I think text is enough to resolve this case. And I think that the text of the relevant provisions is clear. I think read in context, they're clear. I think that established by the state, if it means also established by the federal government, that creates problems that otherwise don't exist in the rest of the statute. And then if it's an on-off switch, it can mean whatever the IRS wants for any given provision, that's problematic. When Michael Cannon and I decided to look into this more, we expected to find all sorts of comments in the legislative history that would suggest that the text of the statute and the intentions of its authors were in tension or contradicted each other. The significance of the dog that didn't bark for me is just the fact that we never found even a single statement, but we did find things that are hard to explain other than with a recognition that the statute was conditioning tax credits, the fact that people were proposing that, the fact that other legislation did that, and so on. But again, I don't think any of that's necessary to resolve this case. I think the text is clear, and I think that I would hope that's how the courts would rely upon it. But as we know, that there are folks that think legislative history is important, and so it's interesting that there is no history that directly contradicts the text.
Yeah, I'm happy to fight this fight on Jonathan's terrain and say the text is quite clear overall. That tax credits ought to be available on federally established exchanges. To the degree you care about the silence in the legislative history, the question should be for you, what's the sort of relevant baseline given the state of what the legislature was thinking about in 2009 and 2010? And the governing assumption was that most states, maybe not all states, Texas might not come along, but most states would establish their exchanges. And so Jonathan's right, not a great deal of attention was paid to what would happen on these federally established exchanges, but that was because everyone assumed they would operate identically to the state-established exchanges. If Congress were truly going to push to threaten the states into forcing them to establish their own exchanges, I would have expected some recognition of that, either in the statutory text or at some point during the legislative debates. So again, it sort of depends what your baseline is, but to me, issuing a threat of this magnitude, which by the way is a quite extraordinary threat to level at the states. Jonathan keeps pointing to the Medicaid expansion, and he's right, that is also a threat, but it's one the states understood during the entire negotiations over the Affordable Care Act and even after. So for there to be this threat that lurked underneath the Affordable Care Act that no one mentioned, no one during the legislative debates mentioned, I think that speaks volumes.
Underneath this debate is a deep methodological debate. So there's a sense in which we are hearing these arguments go past each other a bit. Jonathan's argument sounds quite a bit like a textualist argument, the sort of thing that might appeal to Justice Scalia, for example, and Nick's argument sounds a bit more purposivist, the sort of argument that might appeal to Justice Breyer, for example. Let me ask you to, as it were, switch methodological sides. Jonathan,
I'm still right.
Do you have any... Jonathan, do you have any hope of convincing a Justice Breyer on purposivist grounds here?
Well, I'll say, as a practical matter, I would say no. If Justice Breyer could write an opinion saying that 100 tons per year doesn't have to mean 100 tons per year, I don't think established by the state's going to get in his way. And I think though, if we take purposivism seriously, we have to say, okay, when a Congress enacts a statute like this, it does not have one single overarching purpose that it pursues at all costs. It has a range of purposes, and it's making trade-offs on many margins at any given time. So in the debate over this law, there was a big discussion. Should we have a federal exchange run by the federal government, or should we have states? The House, where there was a broad Democratic margin, federal exchange all the way. In the Senate, there was an extensive debate over this. And the reason for that is that some senators thought it mattered from a standpoint of state autonomy. The Senate Democratic Policy Committee put out a set of talking points about the bill saying, there is no federal takeover. Why? Because there will be only state exchanges. That was the grounds of the debate. And so one of the purposes was to have states do this and to encourage states to do it. And we know, it is indisputable, that other vehicles, the health bill, for example, the bill that was drafted in the Health Education, Labor, and Pensions Committee, conditioned tax credits on state cooperation. So it's indisputable that mechanism was part of the debate internally, and that was because a purpose that Congress had was to induce state or at least the Senate had, was to induce state cooperation. So I think if we take purposivism seriously as something that's going to actually embody an understanding of what Congress actually does, we have to recognize that it's not, expand coverage at all costs. It's expand coverage while not increasing costs too much, while there's state cooperation with no federal takeover that gets 60 votes. I mean, it is not a unidirectional thing, and to me, that's what a faithful purposivism would require you to do. Now, I happen to think that's a task that courts are very unsuited to, which is why we resort to text. But if we're going to start from that purposivism premise, that's the only way to do it with the statute, and I think it supports the recognition that, hey, there's a lot more going on here, and the fact that there are provisions, and there are many, in the statute that have the possibility to destabilize portions of the insurance market, that have the possibility to deny people coverage that used to have it or that otherwise would have it, well, that's because Congress, in pursuing its various purposes, had to do those things when making trade-offs.
Nick, do you have hope of persuading Justice Scalia? And if so, what's your best argument?
I don't want to psychoanalyze Justice Scalia. I happen to think there is a powerful textual argument in favor of the government's interpretation, and it's why I'm sitting here. I'm a pretty textualist guy. I'm not out there saying that you can take the purpose of a statute and use it to trump clear legislative text. I also happen to think, and I believe most committed textualists would agree, that when you try to make sense of text, you look at the broader context. And sometimes words that appear to mean one thing actually, upon reflection, don't. And it would be absurd and ridiculous to construe statutes to mean something other than what the Speaker, Congress here, meant them to mean, right? So here, an easy example. My wife says, do you mind taking out the garbage? And I say, yes. And then I take out the garbage. It would be really nasty if she were upset with me, because clearly I meant no, even though I said yes. What I'm trying to say is there are snippets of legislative text that if you pull them out in isolation, you're going to be misled. If you look to the broader context of the statute as a whole, not looking to its broader purposes, not trying to infuse it with some meaning, not desiring to reach your own policy outcomes, but just trying to make sense of these disparate provisions of the statute, make the whole thing work together as a whole, I think you get to the result that the government wants. That was certainly the Fourth Circuit's view. It understood the force of Jonathan's position. It says, if you read this in isolation, I get it. But gosh, if you read the whole statute as a whole, the argument sort of falls apart. At a minimum, there's ambiguity here. And that ambiguity has to go for the government.
Jonathan, is Nick right that Chevron applies here? And so has he held his burden of demonstrating ambiguity?
Well, two things. One, I'm not sure that Chevron should apply to this sort of question. I mean, if Nick is right that there's potentially ambiguity here, then that means that Congress delegated to the IRS the discretionary authority to decide whether or not there are tax credits and exchanges where states don't create their own. That would mean if tomorrow no state ran its own exchange, the existence of tax credits and cost-sharing subsidies under the ACA would not be something that's determined by the statute, but determined by the IRS and whatever administration controls the IRS. Now, we look at the way the court has handled questions of similar magnitude and whether or not that is something that we can assume it can be resolved at step 2 of Chevron. We see the court has fairly consistently said, we're not doing that. We're not going to do that whether or not cigarettes are regulated by the FDA. We're not going to do that in determining whether or not greenhouse gases are pollutants under the Clean Air Act. So I think that there are step 2 problems in terms of accepting the premise that Congress actually delegated this authority to the IRS, which is what Chevron requires. There's also a long-standing canon. Well, there's long-standing precedent that says that authorization of things like tax credits should be construed narrowly. I believe there's an amicus brief that makes that point. Tax folks can tell me whether or not that's a canon that's followed routinely or just observed in the breach. But on the initial issue, I just don't think under Chevron, as this court has applied it in cases like Bay Mills, in cases like UARG, in a whole range actually of Clean Air Act cases, actually gets you past step 1. Because while we might say that the word exchange is ambiguous, and we might say that is under 1311 meaning as 1311 requires, or does it mean simply in compliance with 1311 requirements, we can argue about some range of ambiguity there. For established by the state to be ambiguous, we need some plausible interpretation of that phrase that preserves some residual meaning for those words. What we don't say is, oh, it's ambiguous because, well, we just don't like the consequences of that. The Fourth Circuit, to get to ambiguity, had to take a provision that is expressly labeled as a requirement, that can only function as a requirement, and say, oh, it's not a requirement, it's actually a second definition. Even though the statute provides other definitions, it's a second definition of what exchange means. And it used that as the basis for finding ambiguity. And I think that, unfortunately, is the method that's used. Let's find anything elsewhere in the statute that we can that might not be perfectly worded and say, aha, it's messy, therefore ambiguity. If that's the way we did Chevron, the EPA would never lose a Clean Air Act case. I mean, it just wouldn't. And yet it loses them on Chevron grounds all the time. Why? Because complexity and poor wording are not enough for there to be ambiguity. There have to be phrases that are susceptible to a wider range of meanings, and we have to be able to interpret, there has to be room for the agency to pursue its delegated authority to interpret them in a way that makes sense. And that just doesn't apply here. That doesn't work here.
I see our audience champing at the bit to get in here. Do you want 30 more seconds?
I can take 30 quick seconds. The notion that Congress didn't mean to delegate to the IRS authority to interpret this provision, I think is really quite far-fetched. Everybody knew the IRS would have to interpret this provision. And agencies make decisions both large and small all the time. This is exactly the kind of provision you'd expect the agency to interpret in the course of discharging its responsibilities.
So now we're on to the next phase of our program. We'll take some audience questions. I want to please remind you it must be a question. And so there should be a question mark at the end of it. I know we have a lot of very knowledgeable people in the room. If you need a few sentences to tee up your question, that's fine. But please, a question at the end and a short preamble, if any. In the back, please.
We have a microphone.
Oh, great.
Hi, David Bernstein, George Mason Law School. I have a sort of different dog that didn't bark question, which I didn't see anyone address. This question is mostly addressed to Nick, which is we have the whole. And I applaud Jonathan Adler for not mentioning Gruber. I'll mention Gruber. We have the videos about Gruber and whatnot. It would seem to be, at least in the political propaganda war, it would be very useful for the administration side if there was some memo, email, other communication by those who drafted the statute that explained what they meant by established by state. Surely somebody, this was certainly a law that the drafting of which was quite opaque, but certainly somebody somewhere thought about what they meant by these words, which were used several times, and there's some memo or email or something explaining it. And since it's only the Democrats who are involved in the drafting, since no Republicans voted for it, you think they have all the memos, they have all the emails, they haven't released any on this issue. I don't think there's any canon prohibiting them from releasing them. Why haven't we seen something explaining, oh, here, established by a state means established by a state or the federal government?
Yeah. So a couple of responses to that. The first is that when you look at the statute, the established by the state language does not look like an advertent sort of, I'm trying to send a signal here that tax credits ought to be unavailable on federally established exchanges. It looks like boilerplate that a staffer used to replace with exchange in a number of places in the Act. I'm not sure it had a whole lot more significance than that. And in fact, there are memos that have come out from the negotiations. There is, in fact, a fact sheet that was released by some of the drafters of the ACA that comes close to being one of the closest pieces of evidence that we have on the other side, which is to say, they talk about the possibility that there are going to be federally established exchanges, and they advert to the fact that tax credits would be available nationwide. Surely, if the drafters of the ACA thought that this established by the state language would strip tax credits on federally established exchanges, that would have been a natural place to mention it. I should also note that Grubergate is a wonderful distillation of sort of what he said was crisp and clear 2 years after the fact, and he said after the fact he misspoke. What is striking is that there is nothing, not a hint from the legislative debates, not publicly, not privately, nothing, that actually confirms or reiterates on any kind of the same terms what he said. If there had been, Congress meant to issue a threat, you would have seen things that looked like what Gruber said at the time. And in fact, if you talk to people who were involved in the legislative process, every single one of them will tell you, no, we didn't mean to issue a threat. And that includes at least one Republican staffer on the Help Committee. So we're not talking here about some conspiracy behind closed doors and a bunch of Democrats who are lying through their teeth. The notion that this is a threat is a fabrication. Let's be very clear about that. Maybe you think the text requires that result. I respect that position. The notion that this is what Congress actually meant is a fabrication.
Jonathan, you want to speak to that?
Yeah, I won't say anything about whether or not members of Congress or their staffers are lying about this, although virtually all of the folks that have signed an amicus brief, congressional amicus brief on the other side, also said if you like your insurance plan, you can keep it. And so either they were lying about the bill that they supported, or they didn't understand it. And that may be true with this provision as well. I think in terms of, yes, there is a fact sheet that says tax credits would be available in all 50 states. But why? Well, because they thought all states would cooperate. I mean, I can show you, there's the president saying every state would do it. Oh, I didn't have it. There we go. There's 2 quotes from a piece that Nick wrote saying, hey, everyone thought every state would do it. Once you accept that premise, then of course you would say every state's going to have tax credits, because they're all going to create their exchanges. Now, on the issue of whether or not any of this was it is undisputed that the HELP bill conditioned tax credits on state creating their own exchanges for a period, I believe it is, of 4 years, and said to states, if you don't impose the employer mandate, no tax credits at all. So the only question is whether or not when the HELP bill and the finance bill were merged, whether conditions on tax credits remained, and on whether the Senate Finance Committee before merging also imposed conditions. But the fact that Senate legislation drafted in the Senate that became part of this bill, conditioned tax credits, is not disputed. And in fact, some of the interviews, some of the memos and stuff, or the memos that have come out, you've had reporters who interview some of the folks in those meetings and say, oh yes, we had language like that in other bills, and we just didn't mean to keep it. But they did. And in fact, in some respects, they actually strengthened the language. They took references to exchanges in Section 36B that were arguably ambiguous and added additional references to established by the state. This was not from cutting and pasting and combining. This was adding language where it would be unnecessary to add it if it wasn't serving some purpose. So in fact, what has come out in terms of memos, if anything, supports the understanding that one of the things people were talking about, one of the things that was drafted in legislative language in the Senate was the conditioning of tax credits. And maybe people didn't think that bill would become law because they didn't think Scott Brown would lose. Okay? And therefore they would be able to get the House bill enacted. Maybe they thought all states would cooperate. Those are both plausible explanations, but neither of those explanations change the meaning of the text. But it's undisputed that that was part of the debate, part of the discussion.
Jim Lindgren.
Yes, one thing that maybe both can agree on is that Paul Krugman is wrong. He said it was just...
We have a mic, don't we?
One thing that both sides might be able to agree on is that Paul Krugman is wrong, since he said it was just a typo, and as I understand Nick's argument that it wasn't just a typo, it was intended to cover particular other things. I was curious about the territories, because it seems to me that it could cut for either side the fact that that the territories were allowed to set up exchanges, and yet there were no subsidies provided for them to do so, which in fact did destroy functioning insurance markets in Guam, for example. I was curious that, because those would be exchanges that wouldn't necessarily be set up by states, and I wondered how this cuts for either side, because I honestly don't know in reading the statutes.
The reconciliation bill actually adds some equivalence language that says that territories can be treated as states. No such equivalence language was ever adopted for the federal government. So I think if the territorial provisions are relevant, they cut in favor of the plaintiffs, both because those provisions, like the Class Act provisions, like the child-only market provisions, show that Congress was willing and able to create provisions that could destabilize insurance markets. And they show that Congress knew that it needed to create an active state equivalence language if, in fact, it wanted things to be able to be treated equivalent with state exchanges. I'm not sure that. What?
They didn't provide subsidies.
They didn't provide all three legs of the stool for territories, just like they didn't for the child-only market. I mean that's so. I think in both respects, Congress knew that state exchanges were a particular type of exchange, and Congress did not always enact all three legs of the stool for the well-functioning of insurance markets everywhere it regulated insurance. I mean, so on both grounds, the idea that you could have federal exchanges without all three legs of the stool and that are not equivalent, I think it supports that.
Obviously, I think you're right to say that it can cut both ways. In the Reconciliation Act, you had Congress go out of its way to make sure that states were treated as if they had established an exchange. You see them express no such solicitude overtly or explicitly to federally established exchanges because Congress, naturally, reading its own statute, recognized that, read in context, understood as a whole, subsidies were in fact available on federally established exchanges. I think it's unfathomable that Congress would have shown such solicitude in the Reconciliation Act towards territories, but at the same time put a knife in the heart of healthcare.gov without so much as saying a peep about it. As for the fact that, yes, the territories didn't have tax credits explicitly authorized in the face of the statute, that's been in fact rectified by administrative action since the DC Circuit issued its decision in Halbig. The more important point is, yes, of course, Congress could establish exchanges that don't work. It's true. Congress can do all sorts of things that don't work very well, but is that the best construction of the statute? Probably not. And if there's an textually available alternative, it really should be one that the courts, and there is here, the IRS is entirely responsible for selecting that interpretation. It should be upheld.
Yes, sir, in the front. The mic's coming to you.
Jim Maxiner, University of Baltimore. Great debate. It clarified the issues. I think Nicholas has pointed us how we might find agreement in all of this. And the agreement is this. It's a methodological issue that I'd like to see our society take up, which is everybody's going to agree that the statute was not as well drafted as it might have been. Now, 135 years ago, in the late 1870s and early 1880s, we started to talk about how legislatures should draft statutes. The result was we got offices of legislative draftsmen. They're dogs that don't bark. Quite literally, we need a legislative draftsman or a procedure for drafting statutes that actually, if not eliminates this kind of issue, greatly reduces it. And we can see that in operation in other places. The OECD has criticized.
What is your question?
My question is, will you, the panel, join in and ask the Federalist Society to say, this is an important issue of textual interpretation. We need dogs that bark in Congress.
It wouldn't have mattered here. And let me just explain. I mean, I think it's a valid point, but it wouldn't matter here, and I think Nick and I would agree on this point.
It's not going to happen here.
Well, no, but the reason why it wouldn't matter here is because once Scott Brown was elected, there was no possibility of having a House-Senate conference that would produce a bill that could pass both houses. That is usually where we get a conference report, which serves as the primary instrument of legislative history. That is typically where the folks that do legislative drafting pore over the language to make sure every I is dotted and every T is crossed, and that every provision in the statute does what the leadership of both houses want the statute to do. None of that happened here. Right? The Senate bill, which is a mess in many respects. It has, in some places, there are section numbers that are repeated. There are other provisions that don't work. Was written as a negotiating draft. This was the negotiating position that Harry Reid thought he could bring to the House without losing folks like Ben Nelson. It was not meant to be the final bill. Congress deliberately and consciously enacted a non-final, non-revised, non-edited bill. That was the deliberate choice. And doing so knowing that the reconciliation process could only offer limited amendments. So for example, were Nick and I to agree that the initial bill did not authorize tax credits in federal exchanges, if Nick were to accept that premise, I think he would agree with me that under reconciliation rules, Congress could not have fixed that because the budgetary impact would have been too large. So I would agree with you as a normal matter, yes, there should be far more attention paid to how we draft statutes. But if Congress is going to deliberately decide to not follow its own existing mediocre procedures, having better procedures doesn't help us because Congress decided, and folks are on record on this, at the time, and they're on record to this day. The choice was to have a bill and to get it passed, and that was more important than what was in it. And that is, folks that were in the room drafting the final language in Senator Reid's office have said that as recently as a month ago.
May I quote Justice Scalia on this very quickly? Garbage in, garbage out. Yeah. And we really need to take a point of having better legislative procedures.
So I just want to make a point about that, right? There is this idea that if we just send these statutes back to Congress enough and validate enough of their handiwork, tell them that they're wrong and whip them like dogs, they'll do better. That kind of textual nirvana, the notion that we're going to get statutes that are the output of a computer program, it's crazy. We've never had it. We'll never have it. Statutes always require interpretation. They're always going to be messy. That's why we look to greater context of a statute. The notion that you would take a single individual provision and magnify it into a threat of the magnitude that Jonathan says it is, right? And use that to basically undermine a legislative achievement that was achieved, again, through elections that we had in this country, and to validate through the courts, like to undermine an actual legislative achievement through a kind of gotcha move like this, I think strikes a lot of people as nutty.
Let me take your patience just one moment longer.
Why don't you pass the microphone?
We have several other people who want to get in.
Let me just say one thing. In Berlin, there's 700 people that the Ministry of Justice, all they do is worry about whether the laws fit together and work.
Ilya Soman.
Ilya Soman, George Mason Law School. So I think one of the issues become more and more prominent in this debate is the question of at what point do we move on from Chevron stage 1 and go to Chevron stage 2, which if we did move to stage 2, most people I think would agree with Nick that the government would win. If it was the case that as soon as there's any ambiguity or reasonable room for disagreement, you go to Chevron stage 2, then the case would be relatively easy. But the Supreme Court has said, as far back as the Cardozo-Fonseca case in 1986, that before you move on to Chevron stage 2, you're supposed to go through, quote, traditional tools of statutory
Do you know what that means?
Well, I'm not sure what that means, which is why I'm asking a question, right? So the question is sort of how far should the court go while still in the realm of Chevron stage 1 in this area before they do what I think Nick probably wants them to do, which is to go on to Chevron stage 2, whereas John, I'm pretty sure, doesn't want them to do that. Like, where should the court draw the line in a case like this? Because I think a lot of the case is going to turn on this, whether it's as soon as there's some reasonable ambiguity at all, or whether we go through a more involved analysis.
This has been a debate in the Chevron context from its inception, right? How do you identify ambiguity? At what point do you stop? Because, of course, all of the canons of construction are designed to eliminate ambiguity. So if you apply any of them with enough force, eventually you can cleanse even the naughtiest statute of ambiguity, and that can't be what Chevron is all about. And the question has to do with your intuitions about what Chevron means to do. And here I think it's reasonable to think that Chevron should not enable courts to countermand a reasonable decision of the IRS, taking the statute as a whole, that tax credits were meant to be available on federally established exchanges. One lurking, kind of interesting question here is, assume for a minute, and the IRS has not done this, and the government's position is not this. The IRS had said, look, we have a particular approach to statutory interpretation, one that is not a textualist approach, but one that's also a mainstream approach, right? It's much more purposivist, and we think that on that approach,
right? The outcome here is that the tax credits ought to be available on federally established exchanges. Is it really the court's role to superintend the methodological choice that an agency makes about how to go about interpreting statutes? Right? Nobody claims that purposivism is somehow foreign to our legal tradition, right? You might not think it's the best way to go about interpreting statutes, but it's certainly an accepted one. So is the court really, I think, being here asked to superintend the methodological choices of the IRS? I think to some extent it is. And I think you should understand that for what it is, which is an aggressive move to make the law of the land look considerably more sort of, it's a choice about methodology that the court would have to be taking a very strong view on. What I will say is that it doesn't matter, though. At the end of the day, I think you don't have to go very far down the rabbit hole of construction to say, I've looked at this statute, there are some indications pointing in different directions, but by and large, the contextual clues here are very strong, that on the text of the statute, read as a whole, subsidies ought to be available on federally established exchanges. I don't think you have to crank the traditional tools very far to get to that conclusion.
What's interesting is that when IRS career staff were initially developing their draft regulations, that's not what they concluded. They concluded that applying their traditional methodology, which is to take the words of the text very seriously, that they would authorize tax credits for the purchase of insurance in exchanges established by the state under 1311. It was only after that some folks upstairs, political folks, recognized this might create problems because some states were acting like they weren't going to create exchanges, that the IRS was told to abandon its traditional approach, which is to be very unsparing and literal about individual phrases, and to do what it actually did. And this came out in a House Oversight report. So we know that if the IRS did what it traditionally has done, it would have not produced the rule that it produced. It would have tracked the tax. And it's in terms of the broader question about Chevron, I think the question, I'm somewhat of a naive formalist. I think Chevron has two steps for a reason. The DC Circuit has articulated this reason is in part by saying that courts are not to look at what agencies are saying at step one. The courts are supposed to do it themselves. That's what the Administrative Procedure Act requires. It also recognizes the fact that when you have a very complicated statute, clever lawyers at an agency are going to be able to manufacture ambiguity by kicking up big clouds of smoke in a very complex statutory structure, and that if courts let themselves be swayed by that, they will. And Nick and I both clerked on the DC Circuit. I think we probably have both seen cases where judges started to go, oh gosh, this is really complicated, I'm just going to defer to the agency. And the structure of Chevron was designed, I believe, in part to guard against that. And so it's not just that, oh, the court must beat the statute until it finds no ambiguity. The court is supposed to make a good faith effort to ensure that every word has meaning, and to find ambiguity where it believes there is a plausible delegation to the agency because a word or phrase or provision is reasonably susceptible to more than one plausible meaning. And what that doesn't mean is, gosh, is there some provision when read literally that seems to constrain the broader purpose of the act? Because we see that all the time. It's whether or not a phrase, like emits 100 tons per year, or established by the state under 1311, is reasonably susceptible to more than one meaning. And I would argue the phrase established by the state, if we believe it can mean established by the federal government, it means states get to tell the federal government what to do. In fact, they're required to do so under penalty of losing their Medicaid funds. It means that the federal government has been wasting everyone's time by finding other ways to fund its own exchanges. It also means that the federal government can't continue to operate its own exchanges because state exchanges, 1311 exchanges, aren't allowed to use federal money to continue operations. It requires basically saying, well, the statute means one thing in one place and one place somewhere else, not because of what the language is there, but because we don't like the way it works. That's not finding ambiguity. Finding ambiguity, saying the word exchange without modifier might mean all exchanges, some exchanges. Maybe context gives us a clear answer, maybe it doesn't. The word pollutant, same thing. Again, look at Clean Air Act cases. The court does this all the time. Sometimes we know that pollutant has a range of meaning. Well, established by the state has a range of meaning. And when the statute tells the federal government to establish something, we've got to find something other than broad purpose to say that means established by the state.
We have a question over here in the front.
Jonathan, Mark Hall at Wake Forest. So this, I like to call it the Potemkin purpose, this imagined pretend purpose of not accommodating the states. just to preview where I'm coming from. But suppose this were Congress's purpose, to say not just that if you don't set up an exchange, your citizens don't get the benefit of the taxes they're paying, but also we're going to trash your individual insurance market, that we are going to keep in place regulations that guarantee that all the national insurers will leave your market and the Blue Cross will lose tons of money. That, to me, feels coercive, to sort of add, to the withdrawal subsidies, the ruining of the insurance market. So I'm just wondering how that can be constitutional. It's not just whether Congress plausibly intended it or not, but could they constitutionally do this, or certainly isn't there a constitutional doubt if we want to reduce it to a point of statutory canon interpretation?
Throw me into that briar patch. What I mean by that is if this statute creates constitutional problems on those grounds, Clean Air Act, No Child Left Behind, I mean, I can probably come up with half a dozen statutes that are gone because they are, by that standard, coercive. I think that's a reason why the federal government has not made this argument. Some state amici have made this argument. Federal government is not, and they haven't told me for obvious reasons, but I suspect that's because they realize if they're going to lower the bar for coercion to reach these provisions, then they are putting at risk a whole lot of things that the federal government does on a regular basis.
Okay,
now,
so
as a matter of the way I would like the spending power to be interpreted, I'm okay with that. I just think that takes existing spending power doctrine and amps it up, puts it on steroids. Takes the Medicaid holding in of NFIB and really jacks it up. So that's the implication of that argument.
So if the government were to make the argument, you'd have to concede the case.
No, I think the text is the text, but if the principle we want to establish is that a whole wide range of existing federal statutes that condition subsidies, that condition other things on state cooperation are unconstitutional, if we want to do that, if that's the way the plaintiffs lose this case, I will sleep very well. And I will have a lot of work to do in terms of things to write and whatever else about various environmental and other statutes that are on that basis clearly unconstitutional as implemented.
I would only say that the four, I guess on this point, concurring justices in NFIB, but the four dissenters on the individual mandate portion of the decision, have a pretty capacious understanding of what counts as coercion. And it's hard for me not to believe that this would fit within their understanding of what counts as coercion. Now, their understanding is not the law, right? The three-justice plurality opinion is likely to be controlling. Nonetheless, you'd at least think that if you are one of those four justices, you should pause before embracing an interpretation of the act that would lead to this kind of extraordinary threat being leveled at the states that is not just money, not just No Child Left Behind, not just Clean Air Act, but is also, as you say, putting a fork in the insurance markets.
We have a question right here.
Hi, Jim Chen, Michigan State. Directly following up on Mark Hall's question, doesn't this approach put real pressure on the non-ambiguity principle first articulated in South Dakota versus Stoll and then reemphasized in Pennhurst Hospital, that if you're going to say, drink the green ink, you states, you need to say, drink the green ink, and not do it with 3 words.
Well, again, Congress has done this before in healthcare. It was undisputed, it was uncontroversial. No one argued, for example, that in 2002, Congress produced legislation that said there are tax benefits for certain types of healthcare purchases that you only get if your state has done things that comply with federal requirements. So Congress has done it this way before, and no one thought it was a problem. In terms of the notice issue, the problem here is that before the states made their decision, the IRS issued and finalized its rule. And it's certainly reasonable that most states relied upon the IRS's interpretation. Now, I do think that from a question of remedy, that could possibly raise interesting questions for the court about what do you do about the fact that the states relied upon the IRS's interpretation. But we know that states like Oklahoma, which filed suit before the deadline on this issue, read the plain text of the statute and said, the plain text of the statute gives us this choice. We are making the choice to forego the tax credits because of the other things that result from that, employer mandate penalties, increased exposure to individual mandate penalties. And so I don't think it was unclear to anyone who read the statute. I mean, Mark was at a conference where I first pointed, at least first time I pointed out this language, I wasn't the first person to point it out, At the University of Kansas, where the person that was going to be running the state health exchange was there. State officials were there. The state insurance officials were there. I pointed out this language. Everyone was like, oh, that's interesting. The state insurance commissioner went on to give a talk about how it doesn't matter because Kansas, like every other state, is going to happily create its own exchange. This isn't coercive. We are being incentivized to do what we wanted to do anyway. Oops. After the 2010 election, that political landscape changed. But up until that point, it wasn't that everyone thought, oh, this is a big club that states over the head with. It was, we're going to give these benefits to cooperating states, and every state's going to cooperate. And everyone thought that's the way this would operate.
But very quick follow-up. The clear statement principle of Gregory versus Ashcroft and cases that follow in that vein very clearly suggests that clarity has to happen at the legislative level by Congress.
Yes.
Can a drink the green ink or else clear statement rule be given effect by an administrative interpretation? In other words, is there a Chevron codicil to the Gregory versus Ashcroft clear statement rule?
I would just say that the lack of clarity here and the magnitude of the threat certainly lends a great deal of force to the government's position here, which is if Congress were going to make this threat, it knows that it needs to issue that threat with some kind of clarity. I don't think the fact that the IRS later offered its view about what the statute meant changes the underlying statutory analysis. I should just point out the Oklahoma point, yes, they filed suit prior to the January 1st, 2014 deadline, long after they had decided on alternative grounds to decline to establish an exchange. There is no contemporaneous evidence from the debates in the states over whether they were going to establish exchanges about whether or not tax credits would be available. It is just fiction.
It's not true. My co-author testified, I believe, for some
Jonathan and Michael said it. I don't doubt that they said it, but nobody took this seriously. I've been teaching this case for a long time. I thought what they said had some force. I understood their claim, but it was not taken seriously at the state level. And even states that struggled long and hard, Kentucky including, right? A red state thinking hard about whether to establish an exchange. It did not enter into the debates about whether or not tax credits were going to be available.
Ladies and gentlemen, oral argument in this case will be on March 4th.
This didn't resolve it?
And the oral argument promises to be superb,
just take a vote of the House.
But I doubt that it will be better than the debate we heard today.
I'm a Democrat, John, but I'm not dumb.